Welcome everyone to our webinar on cost-effective dispute management for legal counsel. My name is Zach. I'm a special counsel in LegalVision's dispute and litigation team. And we've got a great panel. Today I'm joined by Rebecca Wood, who is the practice group leader of the disputes and litigation team here at LegalVision. And we also have Kathryn van Gelder, who is the director of consulting at Law & Order. For those of you not familiar with Law & Order, they work with legal teams, law firms, government agencies across a whole range of different industries, and they manage everything from e-discovery, document review, right through to court services and also managed document solutions. But before we get to the main event, there's a couple of quick housekeeping items. You will receive a copy of the recording and the slides. There will also be an opportunity to ask questions, and this can be done via the Q&A box. And lastly, if you wouldn't mind, there is a survey at the very end, and we'd love to get some feedback from you on this webinar. But first up, we've also got a live poll, and the question is, which challenge do you face most often when managing disputes or investigations? There's a whole range of options, knowing where to start, dealing with too much data, working under tight timeframes, managing limited internal resources, advising internal stakeholders, managing costs. If it's all of the above, or not sure, here to learn, but we'd love to get your vote and we can reveal the results very soon. So they're the results. So managing costs looks to be the top one, limited resources and advising internal stakeholders. And I'm pretty sure that the team will cover some of those topics, if not all of them, very soon. So today we'll be discussing cost-effective dispute management for legal counsel. And that's the rough agenda that we're going to go through. So it was Benjamin Franklin that said, in life, there are two certainties, death and taxes. And I think for the most part, Mr. Franklin got it correct. However, if you're part of a legal team, I would confidently add a third certainty, and that is managing a dispute. If it hasn't happened already, unfortunately for you at some point, not only are you going to be expected to advise on the dispute and manage the dispute, but the expectation is likely going to be that you do it in a really cost-effective way. So on that note, why don't we kick off? Rebecca, I'll start by asking you this question. Based on your dealings with clients, what do you see as some of the more significant legal challenges that teams grapple with when they're attempting to cost-effectively manage disputes?
Yeah, look, it's a good question. And obviously that's what everyone is here to learn about. I mean, I guess from my perspective as being a lawyer that deals with in-house lawyers quite regularly, I think that the thing that I see the most is that, look, and I think we can all acknowledge that being an in-house lawyer is inherently challenging because essentially you're being pulled in a number of different directions. So it's minimizing legal spend, but you've got to protect the business. You may have limited resources, and then you're under constant pressure just to make things go away as quickly and cheaply as possible. And doing that all the while kind of managing what is probably more the business as usual responsibilities. And probably they're the things that you signed up to manage when you took this role. It's not necessarily knowing how to and deal with disputes. So I can see that disputes can become quite a stress and often quite a diversion from those business as usual responsibilities. And so when I speak to in-house counsel or work with them, the things that I observe is the main challenges are really predicting what are the fights that are really worth having, and how do you deal with them. Managing business the stakeholders who just want the immediate answers of, well, are we going to win and how much is it going to cost? So really looking at very complex issues in a very simplistic lens and having to manage those conversations. And really just not having access to the resources, but mostly the information that you really need to be able to make big decisions. And sometimes they can be multi-million decisions that you're recommending. And ultimately, unlike the other business as usual sort of issues and costs that you deal with that follow fairly predictable patterns, disputes have their own logic or maybe lack thereof logic. And so often what becomes or might start as something minor or a straightforward disagreement can often explode into something difficult to manage. And often in-house counsels are really not prepared or don't have the infrastructure needed to kind of deal with those problems as they blow up. The unpredictable nature of disputes makes budgeting almost impossible, and really puts a lot of pressure on in-house counsels to kind of guarantee a particular outcome or costs in what's essentially a very inherently an uncertain situation.
Yeah. So something that you mentioned, Rebecca, and I might throw it over to you, Kathryn, is you talked about being able to access information. So Kathryn, from your perspective, we're in the sort of the modern era, and from your perspective, what's the changing data landscape, and how do you think that impacts the way that legal teams need to approach being prepared for a dispute?
Yeah, good question. So in my lifetime, the data's changed. And even if I just go back 10 years, 5 years, it is changing all the time. We know data is changing at a speed that we're all becoming familiar with how fast it's changing. So one of the things that people can really do is to keep current on all the different types of data that is out there. Most people, when they think of, well, I've got to find some documents, they might be thinking about their emails, and then they might be thinking about their Word documents or their Excels, which are all great thoughts. But then there's a little bit, you've got to then broaden out a bit more, because we're now talking companies operate with multiple different data sources. So not only do they have their emails, but their emails might be linked up to like a SharePoint or a practice management system. So when I send an email now, I might not just be attaching a Word document, I might be attaching a link to a SharePoint, or I might be attaching a link to a document management system. So where are those links, and where are those SharePoints, and where's that all stored? Do I have a collaborative intranet site? Do I have a collaborative site generally? Do I have a SharePoint? How many mobiles are there that are used for a business purpose? So do we have mobiles in our company? What do we have on those mobiles? Are they personal mobiles, or do they work mobiles? Do they have a double SIM? What sort of, if you've got a construction company, what sort of construction data is there? Who accesses that construction data? Who are the project owners? Who are the various parties to that? Do we have media files, video files, LinkedIn? And how many different languages are we dealing with? Are we an international company? Do we need to think about our translations? So really, what I'm saying is, we've really moved off from emails and attachments, it's Word and Excel, to a massively changing variety of data and how that interacts. And I am pretty certain that most companies would be using something like Slack or Teams in their communications. So all of that would then therefore need to be considered as whether it's relevant, how it interacts, and then what's attached to all of that. So the file types are huge.
Yeah. No, it's probably going to be dating myself, but I remember that, when I first started out as a lawyer, like you said, the two main forms of data were probably going to be hard copy documents and also the emails that we'd be sending to each other. Only the most senior people in the firm had emails on their phone. But when I think about the sort of the current era, there's instant messengers. Most people have work access on their phone at some point as well. And like you said, it's going to be a real challenge if it's a personal device as well. I open this question up to both you, Kathryn and Rebecca. So you would have worked with a whole range of different types of clients, some that are really prepared, some not so prepared. What do you think when you work with these various teams, what separates a legal team who is sort of quite well prepared to handle a dispute effectively, and how would you compare that to perhaps the teams that weren't quite ready, didn't have a lot of preparedness going on? What do you think is the sort of the key differences between the two? Maybe Rebecca, do you want to start?
Yeah, I think it comes down to having a proactive versus a reactive approach. So I think it's about in-house counsel making sure that they're embedded within the business. And so being able to kind of identify some perhaps early warning signs, and then making sure that they've got the structures in place that they can implement to be proactive and react rather than that reactive. So, often in-house counsel will come to us when things, I guess, have really blown up, whereas probably the most effective relationships and dispute management will come from engaging either your external assistance, so whether it's external counsel management or if it's like an organization like Law and Order to help you collate information earlier rather than later. I think that there can be a bit of a myth that spending money to kind of resolve things is not a good use of money, and you may as well save that budget for when things go really bad. But I think from my perspective, I've seen you end up spending a lot more time and a lot more money being reactive rather than proactive. So an example of perhaps a good proactive team would be having really good document retention policies, understanding how your organization communicates, making sure that you've actually got some guidelines and policies in place to make sure that people are following those processes. So kind of picking up on some of the things that Kathryn said, you want to actually understand the way and the way that the people in your organization are communicating with you or with each other. So if you've got to collect information, you know where to go to. You sort of don't want to be scrambling, trying to understand, well, where might this information be sourced? So if I'm thinking of an example recently that I've worked with an organization respond to a regulatory investigation, information was produced. I don't think it went, I don't think it wasn't a proactive structure. They just sort of found what they thought that they had that responded, sort of didn't really take a big step back and think about all of different other information sources. They got a request for a second production of information because the first production, there was a lot of gaps. When we sort of worked with them to identify a lot more different information, essentially it looked to the regulator like they were being evasive, that they produced information and that was actually contrary to the first document production. So I think because it was rushed, it wasn't properly considered, they didn't really understand where all of the information was. The outcome was probably a bit worse than it would have been if they'd actually spent the time to do things properly and actually really understood the way that information might be stored within the organization.
Yeah, I think that's really helpful. Well, I think particularly the document retention policy is very useful. I can't tell you how many times I've been involved in litigation, and as soon as it kicks off, the key witness has just handed in their notice of resignation, and it makes it, it's going to be near impossible to try and track them down and find out where they stored everything. So having those policies and procedures in place is really, really key. Kathryn, is there anything that you'd like to add in terms of what good teams, bad teams?
Oh, well, all of the above of what you and Rebecca have said. I would really emphasize that pausing and planning that Rebecca talked about. So there's often a temptation there's often three reactions. First, sometimes is overwhelm. Oh no, what am I going to do with this? And then at the last minute, holy moly, the deadline's approaching and we've got 3 days to get it. Often we get, people coming to us and saying, I've got this deadline. And then you go, but you've had this for 4 weeks. What have you been doing all this time? And, it's kind of been hidden. Not too many of those anymore. The second, where the people who struggle is where they just dive in. And I think that's exactly the war story that Rebecca's just told. If you pause and plan, you get the time to really consider what your data is, and you've done that preparation to know who holds the data and where to go and who to speak to. So you know your IT person, and you know what your IT person can and can't do at a drop of a hat. You know what your retention policies are within your practice, so you know whether emails are about to be archived, whether when an employee departs, where their emails sit, where their data sits, where things are. So if you pause and plan, I know what I've got, I know what I need, and I know where to collect it, then you don't have to go back and repeat.
Yep. We might sort of drill down into some of the more practical steps. So, Rebecca, if we could pretend that someone in this webinar has just been copied into an email from the business and it has the faint smell of a potential dispute. We've all experienced that. The business thinks by copying in the legal team, they've covered off their duties. We've copied in legal, someone else is going to handle it now. What is a real practical step that someone could take in that situation?
Look, this is often how disputes will start or come onto your radar, and a lot of people will just think by CCing you, they've done the right thing. So again, probably coming back to kind of that proactive, mindset. So I guess the first thing that you probably want to do is make sure that people are coming to you if there is a potential issue, even if it's just to kind of have a preliminary discussion about, look, is this something that we should be worried about, so you can plan with them. Look, we all know that that's not going to always happen in practice, and so these emails will kind of land on your desk. So I think the first thing that you just need to do is just say, okay, everyone, let's pause. So it should be, either a reply all or a quick phone call to say, look, I don't send an immediate response. I need to kind of have some time to assess this, and set some internal deadlines for yourself to say, look, I need at least 30 minutes to consider, what's going on here, and then let's have another discussion. So giving yourself that time and space to really think it through. It might be thinking about, do I actually have the info? Do I actually know what's going on here? It seems to be, for example, this email is about a contract dispute. Well, do I have a copy of the contract? Who were the people that were negotiating it? So mapping out who might be the people that I need to speak to find out a little bit more about what's going on. Is it appropriate to be putting on a litigation hold? So, for example, communicating with the relevant people to say, this is an issue. I want everyone to collate at least the baseline information of what I might need to kind of be able to manage this. Think about, do you need to provide advice? So thinking about privilege. So look, we all know that, that you as in-house counsel, privilege can certainly apply to the advice that you've given, but privilege can also be quite easily waived when there's, a whole lot of stakeholders on an email, and it's not necessarily for the dominant purpose of receiving legal advice, etc. So you might want to implement some frameworks about making sure that the communication and then the advice that you're giving will be protected by privilege. Top tip, I did another seminar on privilege in the in-house environment. So if anyone wants a link to that, we're happy to share it after this session. So I won't go into privilege in too much detail. And then I think it's categorizing the risk. So look, is this a high risk? situation, or is it a low risk situation? Obviously, low risk things can still have the potential to become bigger issues, but it might be, doing a quick identification. So look, is there a clear and present threat of legal action? If so, it's probably a high risk scenario. Is this some sort of a commercial disagreement that, has the potential to become a dispute, but still perhaps at the lower risk spectrum? So, undertaking that risk assessment and then thinking about, well, who should you be notifying? So do you need to brief the board? Do you need to speak to insurers to put them on notice of a potential claim? Should you be thinking about engaging external counsel, just so if something does become big, they've got notice of it and they're aware of it, and then you don't kind of have that last minute scramble, firstly trying to find a lawyer, external counsel that can support you, but you've also got a relationship with someone that's known about it and will be able to kind of step in pretty quickly. So I think it's important to, to be balanced in the approach. We don't, I know that probably a lot of in-house counsel don't want to be seen to be catastrophizing particular issues, but I would say that it's generally better to be overly cautious than trying to unscramble an egg later. And so, a quick and upfront intervention, can sort of help prevent long-term issues, and then a cost escalation as well.
Yeah. And Kathryn, from your perspective, what is some real low-hanging fruit that people could take in terms of, you spoke about all the different types of data that's out there. What's some real low-hanging fruit in terms of steps that they could take to try and get their data house in order?
Well, so to get to the low-hanging fruit, once we've, and I'm going to repeat it, paused and planned, because it's so important, really, when you've got a trigger point and you see that you need data, sometimes people go to a litigation provider when they've got a lot of data. I noticed in that poll, people don't think a lot of data is at all their priority. I think it got a big 0. Sometimes it can be complex, the data, because you've got the multiple data sources. Sometimes it's a small amount of data, but it's just useful to be able to host it in one place. So really what you're looking at, it's not always the number of documents, it's what your corpus of data is, and understanding your resources. So, you can go to your litigation provider and ask them for some support in the techniques of how to get through the data, how to work out if you can manage your data using a litigation support provider and a review platform, you can easily tick off some of the low-hanging fruit by either saying, I can easily see which of my data is in, or I can easily see which of my data is out. And often, you get a lot of data and a lot of it is rubbish that you don't need to get involved with, and a lot of it is clearly highly critical. But also using a litigation support provider, you can start to really flag those privileged documents really quickly and really easily. There's a lot of techniques out there that can highlight privilege terms. So you can say any document that seems to hit these privilege terms, we're going to put to one side, and I'm going to get a lawyer to review those ones to make sure we don't hand over anything privileged. Well, we busily look at this issue, which seems to be the most key issue. And then when you talk to your litigation provider about, what sort of goals you're trying to achieve, what your deadlines are, then you can consider whether that litigation provider can either provide you with some more lawyers, or whether we use some of the tech out there that gets through the review a lot faster and in a much more efficient fashion.
Yeah, no, I think it's your point about knowing where to find things at short notice is sort of really critical. I've got a newborn, sort of reminds me of the times when I need to find maybe a new set of pajamas for the baby because they're wet theirs. It's the middle of the night and there's a pile of laundry. And it's the difference between trying to sort my way through that pile of laundry as opposed to knowing that it's in the second drawer, because my wife has put it away for me, which is quite nice. And I think sometimes that's sort of like, I think the difference between sort of having your data in order, knowing where it is, and then trying to make a mad scramble for it later. So we talked a lot about being prepared, but I just want to quickly touch on proceedings. So Rebecca, quickly, proceedings have kicked off. In terms of the phases of litigation, where do we usually see sort of a lot of costs being incurred? And I suppose for the uninitiated, what do you think makes these phases so conducive to a cost blowout?
Yeah, look, I mean, I think everyone knows discovery is traditionally very expensive, and I think that's because we think of it as, probably again, Zach, it's showing our age that it's, we probably think back to having like a room full of lawyers reviewing documents day in and day out, flagging things that might be discoverable. I think technology's come a long way, and I think that can be discovery in itself is probably a process that can be managed in quite an efficient and cost-effective way. And I'm sure Kathryn can speak a little bit more to that. The other area where I find the biggest and unanticipated cost blowout is really putting together evidence. That's because it is very document heavy. So it may come before or after discovery. So it often involves requesting information, and then actually we need more information. You talk about this, surely there's a document. And so I think if you haven't collated all of that information first and reviewed it, it can be a very protracted process. Evidence involves a lot of drafting, even just kind of putting, if you're managing things yourself in hard copy in a very traditional way, not using technology effectively. I mean, you could have people just spending days building an exhibit bundle, and so it's a huge time suck essentially, and it can be really costly as well. So look, they're the key to the main areas where we find a lot of difficulty in trying to manage costs. Like I said, when we're putting evidence together, a lot of issues tend to come out that perhaps we didn't know about, and so that can contribute to a cost blowout as well. But yeah, they're the main areas where you want to make sure you're a bit prepared. And I'm sure Kathryn can perhaps, talk about how effective use of technology can help bring those costs down a bit.
Kathryn, do you want to take us through how you would usually assist, or in ways that you probably would assist during these phases, and how you'd make it more cost effective?
Yeah, sure. So, I mean, you're right. Discovery is often the place where people come to us to get support, because it is traditionally a big piece of the work. And there are many different ways of approaching it. So the technology that's out there that people might not be aware of, for a long time, the courts have now been mandating the use of what's called CAL or TAR, which is an AI. It's not a Gen AI, but it's an AI tool that reprioritizes the review of documents. So in the same way that Spotify learns which songs you like and which songs you don't like, and gives you the ones that you like first, the CAL will learn, as the reviewers manually code a document, which documents are likely to be relevant and which documents are not likely to be relevant. And it keeps re-ranking it. It doesn't remove the documents. You can still see them, but it keeps re-ranking it to give you your most relevant documents first. We found that people save days and days of review time by using that technology, which is why the courts mandate it. There's the new introduction of the Gen AI technology, which the courts are still not sure about exactly. There is definitely from the Supreme Court says, you can't use it to draft documents. It's still a bit open on review, but that can certainly help you with your first pass review, and is probably still permissible. And that just helps you separate the wheat from the chaff, what might be in and what might be out. Again, it doesn't remove it all from your view. If you want to find the stuff that it doesn't think is relevant, we certainly recommend looking at it. So you've got those sorts of techs, but also just getting your documents into a review platform. You can keyword search it, you can concept search it, and then you can also QA it before it goes out really quickly, and reduce it from a massive data source to a much more sensible data source by removing all your duplicate documents, because as we all know, the same document exists multiple times in a company. So rather than looking at the same document 5 times in different forms, you just look at it once.
Yeah, and look, it wouldn't be a webinar on managing costs without talking about AI. So we'll quickly just before we sort of round off this session, I might ask you, Rebecca, a question about AI, which is, look, it's the hot topic. Everyone wants to use it, and it is seen, or there's this assumption that it's going to be the great savior in terms of reducing time and costs. But are there any warnings that you'd give to legal teams about using it, particularly in disputes?
Definitely. I think it's interesting you ask. I was at a networking function the other night at Chambers, and it came up as a topic, and a lot of traditional law players were saying, "Oh no, we don't use it," like as if it was a bad thing. And I'm like, no, we use it, and I think that most in-house counsel, most clients would have an expectation that their lawyers are using AI and that they're getting the efficiencies out of it. So I think it's, if you're working with external counsel, I think you should be upfront and ask, well, look, how do you plan to use AI products to make this a more efficient process, and what's the benefits of it? We need to make sure that we're using AI responsibly. I mean, I'm sure most of us are getting the lawyers' weekly updates about another lawyer who's been dragged before the courts, embarrassed about hallucinating cases and things like that. So it's making sure that if you're using it, you're using it as a tool, and certainly not a replacement for any of the things that you should be doing in terms of analysis. I guess my top tip for in-house counsel would be making sure you've actually implemented a policy on how your organization should be using AI. So for me, a horror story, well, not even a horror story, it happens on the daily. So I will provide some recommendations or ask for information from clients. And this is not exclusive to the in-house counsel environment, but I get information given to me that's clearly gone through ChatGPT. Now, we know that ChatGPT is not a secure, source. It's an open platform. You'd be really wanting to make sure that you've got processes in place to make sure that the people in your organization are not dumping their, company information into an open source like that, or advice or recommendations that you might be giving, because you actually might be inadvertently losing privilege by sharing that information in a public source. So I think, again, it's coming back to being proactive about the way that AI is being used, either by the people that you work with or also within your organization.
Yeah, and I think when it comes to AI, and this goes back to your point, Kathryn, is that it is so easy to create so much more content now.
Yeah.
I remember when we were juniors, if it took us 3 hours to draft a letter, that was 3 hours of time spent drafting one piece of one document. Now, with the use of AI, the amount of content that you could potentially produce in 3 hours, and that is arguably all captured if it was quite a wide scope discovery. So it's just got to be mindful as well. Yes, it can reduce time, but there is also a downside into how much content you can actually create. We're quickly running out of time, and I do want to save some space for questions at the end. But just, do you have a final thought or just one last tip that you give everyone just before we head into the Q&A section?
Look, I'm happy to jump on that. So I think if we're following kind of the trend of this topic, which is being proactive, I would be wanting to walk away from this seminar either comfortable that you have in place, or have putting a plan into place to make sure that you've got policies on how to store, share, and eventually destroy information within the organization. That you've got a process in place to make sure that the communications that you're sharing are going to be protected by privilege, and also some policies that deal with AI usage.
Kathryn?
My big takeaway would be to really understand where your data is in your company. Who are the people who know? I would be speaking to your IT person and saying, where does everything sit? Where does everything go? When people leave, when people stay, where do people save things? If I had to collect emails and attachments, how would I do it? How could I do it in a hurry? And how can you help me collect it? And then the final thing, which I have said, I think 2 or 3 times, is pause, don't jump in, and plan. Reach out to people who've done it before, pause and plan. Anything that you do once is great. Anything that you have to repeat multiple times gets costly.
Yeah, that's right. Don't leave the laundry pile of data. All right, so that concludes the main part of our webinar. But before we get to your questions, I'm going to quickly run through some information. If you found today's session helpful, we do have a publication. It's called A Guide to Resolving Business Disputes. You can use the QR code to download a copy, so feel free to do that. Also, if you're interested, we have an upcoming webinar on ACCC merger reforms and what in-house counsel needs to know. That's on the 18th of September, so please register for that. And I just want to do a few quick plugs. Rebecca and I regularly work with clients to advise on disputes and discuss strategy with them. If you're interested in having a chat with us, or you have a current dispute that's bothering you, please feel free to get in contact with us. And also, one of the best ways to try and minimize the risk of a dispute occurring is to have access to good legal support. LegalVision offers this through a desk extension, which allows us to be an extension of your legal team and provide legal support for your business as usual needs at a set cost. And on top of that, our desk extension clients get access to discounted hourly rates. Lastly, if you want to discuss anything that you've heard Kathryn mention, or any of the warnings that she's had, I'm sure she'd love to hear from you. That's her contact information. Feel free to get in contact with Kathryn as well. And now we'll have a look at some of the questions. There were some pre-submitted questions, and we might start with one of those. So I'll open it up. What are some examples of the practical applications of AI in how costs could be managed?
Did you want me to take that, Zach?
Kathryn, yeah, sure.
So in our review platforms, there's a lot of AI, and there's AI that has been agreed to be used by the court. It's not the Gen AI, so it's the old AI that has been around for decades, actually, but is just being refined as time goes on. And the way we use it to manage those costs is, like I said, it's that sort of cow review, that continuous active learning that can keep a track of what you're reviewing, keep it relevant to the issues that you're reviewing, and it can also operate as a QC function as you review. I've had lawyers using the CAL, and it brings up a conflict, for instance, and I'll say to the lawyer, look, the algorithm seems to think that this document might be relevant, but you've coded it as not relevant. And I've had lawyers say, oh, yeah, the algorithm is correct and I made a mistake. So there's a really good QC function. And as the courts get more comfy with the way that the Gen AI review works, that's where really you'll be able to help with the costs, because you'll just whiz through that first line review so you can get to that second most important part quicker.
And Rebecca, maybe I'll ask you, but in terms of sort of what are some of the ways that you would use AI in your day-to-day that you think could help manage costs? And I think when we talk about costs, often we think about dollar signs, and that's probably the main one, but cost also comes in the form of stress and also time. So yeah, what ways would you use AI in your day-to-day?
Yeah, look, I think it's about the way that I would use it is to try and digest a whole lot of information so I can get on top of things quickly. So, often I'll get I've got to jump on a call and advise about a dispute, but will have received about 50 attachments before. And so, I can use an AI product to build a chronology of the information so I can kind of digest it in a easy to understand way that allows me to get up to speed on things quickly. But then I also might use a product to house a whole lot of information. So if I need to prepare a proof of evidence from someone, I've got the documents ready to go and I can link it. I can use that data to build document bundles that I want to go and speak to a witness about. And I've got that all audited and tracked through. So probably a lot of the products that Kathryn could speak to. Probably we won't have time, but that there's a lot of ways that it comes with an upfront cost. But I think you also need to think about it in terms of, well, it's balancing a disbursement cost to house technology, to use technology versus the time that might be spent, whether it's within your own organization if you're managing it in-house, or it's an external cost that might be incurred by not using the technology. So it's a bit of a balancing exercise there.
Mm-hmm.
I would just add on to that, Zach, that I think the big key takeaway that most people think about AI these days is it's not the AI that's going to replace, anything. It's the people who are using AI who are going to become the most efficient and using it effectively. That's really, it's there and people are going to be using it and it's going to be speeding up people's work.
Yeah. So we've had several questions come through about alternative dispute resolution mechanisms and in particular mediation. Rebecca, where do you see is their role in relation to a dispute? Do you think that they can be used well to reduce costs, or what are some tips or advice you'd give in relation to ADR and mediation?
Yeah, look, if you come to me with a dispute, I'm always going to try and see if you can resolve it without going to court. I think once we're in the court system or dealing with a particular structured process, we've lost control to an extent of the outcomes that you can reach. So I think it's a matter of approaching or using mediation, which I often find is really good. But making sure that you're going in there really prepared. So there's no point in going to a mediation because you think it's just going to save money, but you haven't done the work. You don't really understand what the legal issues are. You don't understand what the consequences could be if you can't resolve it. Or you haven't thought about, well, what's a creative out-of-the-box solution that I might want to get out of this mediation that I couldn't get out of a court process. So I think it's there still is a degree of work and prep that needs to go into a mediation. And I think making sure, that you've done the work and, that you're prepared to go to court if you can't get the outcomes that you might reach in a mediation. Another word about arbitration. I see a lot of clauses in contracts where the dispute resolution mechanism might be an arbitration. Arbitration can almost be just as expensive and time consuming as a court proceeding. In fact, it's almost just like a truncated court proceeding. So again, I would still be trying to explore your alternative dispute resolution processes other than an arbitration before you get there as well.
Yeah, look, from my perspective, I think mediation can be a really effective method to resolving a dispute. There was a recent federal court case or judgment that Beck and I were discussing, and the court fully endorsed sort of the idea that the parties try mediation before sort of incurring the costs of a full-blown litigation, and so that was something, and it was quite nice to see that the federal court sort of supported that method as well, and they're also particularly conscious where they understand that the potential costs of running a matter right through to a hearing is going to just make it completely uncommercial for both parties. And in that particular judgment, that's sort of that was the shining star as to why they were trying to encourage the parties. When I say encourage, force the parties to go into mediation first.
Very often, Zach, as well, you'll find that, you know, parties do need to sift through all of their evidence as well to get prepared for that mediation. If you do it right on that first phase and mediation is unsuccessful, you're then ready to go if litigation commences, and you're not, again, repeating that work that you've already done.
Yeah.
You kept track of it, ready for your evidence.
Look, I think we're at time. I really want to thank everyone for attending the webinar. I really want to thank Kathryn and Rebecca for their time as the panelists. Sorry if we weren't able to get through to your questions, but please submit your details in the survey at the end, and we can see if we can provide assistance with any questions we get to. And also, if you wanted to hear more about the desk extension option or to reach out to Kathryn, please let us know through the survey. This is a free webinar, but we also value feedback, so please let us know if you have any. But other than that, I just want to say thank you for joining us.